to everyone, in particular to the candidate. The advisory group of experts in its full composition continues with interviewing the candidates for the positions of a judge at the Constitutional Court of Ukraine. And the next candidate we're going to interview now is Mr. Ratush Volodymyr, a lawyer who has been admitted to the competitive selection process by the Council of Judges, Ukraine. I'm going to give the floor to the Secretary of the AGE, Mr. Yaroslav Romaniuk, who will moderate the interview. Yaroslav, please.
Дякую, пане голово.
Thank you, dear Mr. Chairman. Volodymyr Borisovich, greetings. Greetings to everyone, all those who are watching our broadcast, all 6 members of the AGE present, primarily AGE Chairman Aleš Zalar, who participates remotely. And physically present, we have the members of AGE Hanna Sukhotska, Maureen O'Connor, Natalia Kuznetsova, and Oksana Vasilchenko. And me, Secretary of AGE, Yaroslav Romaniuk. We also have Deputy AGE members present, Thomas Griffith, Richard Barrett, Mr. Marek Zubik, Vasil Shakun, and Volodymyr Kuzmanko. Volodymyr Borisovich, we had time and we have accumulated a lot of information about your candidacy. Also thanks to communication with you in the framework of the answers that you have provided for our request. Today's aim of our today's communication is to provide you a chance to shed some light on the moments that still remain unclear to us, or give you the chance either to debunk the doubts that perhaps emerged relating you adhering to the standards of high moral qualities. You do understand that, right? Yes, I do. And let me draw your attention to the fact that under Part 8, Article 7 of the methodology, you cannot provide today new information or documents that you didn't submit earlier, or the documents or materials that we requested, but you haven't provided it for some reason. Altogether, if there are reasons for this, we can make the exception and study those documents. Do you understand this? Yes, I do understand it. I also want to inform you this interview is being recorded and broadcast live on the resources of the advisory group of experts and the website of the Constitutional Court of Ukraine. I also would like to urge members of the advisory group of experts and you, dear Mr. Candidate, if we have information on the sensitive data or information with a limited access, we are going to restrict the broadcast and we shall communicate only here for such sensitive information, not to go beyond the limits of this room. Next thing, dear candidate, I would like also to emphasize that the duration of the interview is approximately 1 hour. And please answer in the laconic way, to the point, trying to do it in the time limit of 3 minutes. Not all members of the advisory group of experts know Ukrainian. There are English-speaking members. So if you do not know English well enough, you can use the headset that is on the table. And if you see the blue color, it means that the simultaneous interpretation is on and you will understand the questions being asked to you. Before we finish the interview, we will give you the chance for 5 minutes to address to the experts with your concluding remarks. So we are ready to begin the interview now. And the rapporteurs on your candidacy are going to ask you prepared questions to obtain a full information on your candidacy and to draw the corresponding conclusions on your compliance or in compliance with the high quality standards. Allow me. So first the question. We have questions for you. Sorry, okay. So Volodymyr Borisovich, tell us please, or explain your motivation when in 2016 you participated in the competition for the position of judge of the Cassation Commercial Court within the Supreme Court. What was your motivation for that participation? The Cassation Commercial Court. Thank you for your question. I would like to use my right and in the framework of the regulation and time frame on the preparation for this question. Volodymyr Borisovich, 3 minutes for the answer, but not for the preparation. Oh, okay. Okay, I start answering. Okay, I will try to just speak. I have already mentioned in my answers, written answers, and if it was not clear enough what I was trying to communicate, but I will try to clarify this for you. Thank you for asking this question. My first higher education, I have the economic education and the experience of work in this area for more than 10 years. So I was the chief accountant and advisor on economic issues and consultant. So I have made conclusions. When I have obtained the second education as a lawyer and having gained experience in the sphere of law as a practicing lawyer, so this was not enough for me for my self-realization. I wanted to combine the opportunity. Maybe this will sound like too loud, but I wanted for the benefit of the society to use my knowledge, my skills, and I wanted to offer the society everything that I could to make my contribution in the development of the economy of Ukraine, to become the judge. And this opportunity was given to me by the amendments to the legislation when they made it possible that lawyers could also participate and non-judges. And at that point of time, I realized that this was a breakthrough in the domestic legislation and in the sphere of democracy in general. So for the post-Soviet republic, this was the unheard progress. Thank you. That's in brief. Volodymyr Borisovich, please explain why having such a high aim for holding this position, you did not submit the full set of documents. Didn't you know the laws or did you ignore the laws? I can specify that I cannot deny your assumptions. Unfortunately, completely, I cannot deny it. So partly, maybe I did not refer to the consultants in timely manner, but right now, this question can be tackled in a mobile way, as we have the legislative base, everything on internet, free access to it. You can find all that information. But at that time, it was a bit more challenging to do it. So my not exhaustive set of documents that I have submitted. I will remind you, you did not submit the declaration and you did not agree to submit the special law procedure. Thank you for reminding me. The time has passed, so I forgot. Well, I do not deny this. I had technical difficulties, as far as I remember. It seems to me that I just was pressed for time. I was not in line with the time limit for the submission of declaration. I was in the situation. Well, it was, of course, my fault, but I mean, I admit that this was because of the time issues. Okay, I see. Because of course, I did not have any fear, so to put it. Thank you. Madam Sukhotska, please.
I have to you a different question. I put it, yes. Yes, I will speak in English.
Yes.
So, Mr. Volodymyr, I have to you another question. In 2019, you were not admitted for registration as a candidate for the position of the President of Ukraine at the regular election of the President of Ukraine. The main reason for not admission was that you did not pay a financial pledge to the special account of the Central Election Commissions. It was 2,500,000 Ukrainian hryvnia. The need for such mortgage is envisaged by Article 49 of the law of Ukraine on the election of the President of Ukraine. So my first question is, when trying to register as a candidate for the post of President of Ukraine, did you read the content of Article 49 of the law? Because it was everything clearly regulated in the law.
Say question, and my husband will in Ukraine. Excuse me, but my language is not enough for to.
You need to speak in your own language, please.
Yes. Yeah.
So the question whether or not I was aware with the content of Article 49 of the law of Ukraine on the election of the President of Ukraine. Well, yes. At that moment, I was familiar with it. But I will tell you my secret. And I think that you will not tell about this to anybody else. I'm joking, of course. I know that everybody can hear us now because there's a free access to this interview. So my aim for the participation in the competition, one of the aims was to pass this test, for the state to pass this test, because I have specified that I did not pay this financial pledge when I submitted documents, because I thought that at that moment this article contradicted the Constitution of Ukraine that guaranteed the equality of the citizens, not only in the domestic legislation, but also in front of the international legislation. It's the human rights in the world that Ukraine has joined and ratified these laws. So this was not legal, neglection, but I state that since, according to my financial status, so person who doesn't have such income, they are like deprived of this right. So the person cannot participate in such procedures. And Article 49, I have referred to the Constitutional Court, and by decision of the court, they have rejected it. And then I went to the also, I have sent the complaint to the Constitutional Court of Ukraine because of this inconsistency. Thank you.
But I fully understand that you took the action being fully aware that your activity is against the law when you decided to start as a candidate for the president, as you explained it now. And then both your cases were rejected or not considered into account by 2 courts. And then you said, when the commenting upon your participation in the election and the decision of the 6th Appellate Administrative Court and Constitutional Court, you said that the court passed a strange decision to fit the oligarchs' needs. And I would like to know if, do you have any evidence that would confirm that the consideration of your claim was made by the 6th Appellate Administrative Court under the influence of the oligarchs? Because you said it openly, it was even published. So what is your opinion here?
Thank you very much for the question.
So,
Якщо надаючи питання
if
відповідь по
so answering this question, I want to also connect it to the previous answer when I told you that I was aware that I was violating the law, knowing about existence of Article 49, but I also knew about the norms of the Constitution that gives the direct right. So I think you can agree with the alternative opinion here, but I respect your question. And as for the way I expressed myself, I confirm it was weird, as I called it, and I have the right to stick to this opinion, even though I do respect any decision by the court that got the status of the final decision. And I have no doubts, and I don't doubt it being legitimate. But the personal opinion or the dissenting opinion is something that I can have. At that point, when I referred to the court appealing or challenging, as I thought, illegal grounds, it turned out that I was wrong because the 6th Appellate Administrative Court has indicated this, but I used the right of the cassation complaint. So on the part of the corruption element and calling it weird, there's the principle without proving the evident, and I will use it. And the last events in the Supreme Court, I shall not give you names, but when the chairman is under big doubts of his integrity, and it gives me grounds, actually. And in the courts where I had cases and represented the interests from the panel of the criminal proceedings, I had 2 judges and they got 2 sentences. And the same procedure is now for one of them on his level of integrity.
Decision taken by 2 different courts, and 2 different courts decided in the same way. And do you think, and maybe you took into account, that your argumentation could, for outside observers, be perceived as undermining public confidence in the judiciary?
Thank you. I have predicted the continuation of this follow-up question, and I got it. But I would like to say that the world practice in other countries, it is limited by the Court of the Appellate.
In Ukraine, we have 3 stages, and there is cassation court also. That's why these assumptions I mean not assumptions by Ms. Sukhotska, but general assumptions as for specialists in law, that I would agree with such a decision and not to put it under doubt, but the current legislation gives this opportunity to express legitimate doubt without criticizing and without some illegal approach and having more evidence. This maybe tells us about our democracy when cassation establishment cannot agree to some conclusions. I think that it can happen, and this is like there is philosophical question if they agree to everything why the cassation establishment should exist. And also consideration, there was also an order that at first I have to address the Cassation Court and then I have the right to address the Constitutional Court. So there was a requirement of our judiciary system to act as it is foreseen by the order to defend my own interests.
Thank you.
Володимир Борисович,
Mr. Volodymyr, I would like to pass to another block of questions as for declarations. So under the declaration for 2017, 2022 and 2023, we analyzed them. So in your declaration for 2022, you state that you have cash savings for $20,000. However, in 2023, you do not mention about these savings. Can you please provide us with the source of these cash savings? Because, for example, as I see, they are not declared in 2017. And why you do not declare them again in 2023? Thank you for your question. To clean myself and to provide you an answer for your formation of a correct vision of my candidacy. The life flows in such a way that nobody is eternal and our parents pass away and we live through our lives and then we inherit from them. It's a natural process and there is a civilian code procedure. This was the procedure I passed through. So in 2017, my parents passed away and I became a heir of their property. And one of the objects, the village house, was offered for sale, and together with other heirs, in my turn, alienated this property through the sale purchase agreement. I provided you with agreement. So all this is in the materials of my dossier that confirms the fact that there are legitimate sources of my income and possessions that I declared. As for 2022, in the declaration as of 2023, partially the funds were spent by the family, and nowadays the sum is insignificant. It changes constantly because unfortunately it is one of the main sources to provide for life, given the absence of my income that I have stated in my declarations. This is regarding the question I would like to provide an answer, and this is my answer. This is your right, how to provide an answer. We will analyze the documents, including your answer. Let's continue. So, your position, as for the fact that in none of the declaration you declare the incomes of your wife. As far as I know, as far as we know, he works and he has her income. Why don't you declare your wife's income? Thank you for your question. It is really so that my wife works. She is not a civil servant, but annually she submits a declaration. And her income can be traced in open sources, and I provided you with the information with her surname, so I can confirm my statement that I have already stated, and I see that the AGE studied all my answers about the fact that together with my wife, we have separate budgets. This is, my wife is entitled to declare, to use her income as she wants. I state that given such a right as of consent of my wife, we do it. So I don't think that it can be an issue in my career because her incomes also can be traced. But given her consent and my consent, so at mutual consent, this right was implemented as I declared. So I declared my incomes, my expenditures. I declared it really and actually. So what I wanted to mention to Mr. Romaniuk at the beginning of the interview, that I would like to present to the AG the documents that confirm my incomes, correct my income, given the fact that I couldn't obtain and present them before. This is right to inherit from my wife, dated from the 23rd of February 2024. Mr. Volodymyr, I think that Mr. Yaroslav explained to you about the fact how the documents should be submitted. So now we're talking about these expenditures, for example, about these $200. You say that you just spent them. Maybe you bought something. How? So this is the open question, how you spent them. Is it correct? Can I answer you, please? If there is a question, I will answer them. Yes, I would like also to state a question that I haven't obtained the answer. As for your wife, now you said that together, you live together, you count your income together, and you should understand that when you submit your candidacy for such a respectful, important position of a judge of the Constitutional Court of Ukraine, you should understand that we are really careful to study your incomes and incomes of your family, because this is expression of your attitude towards the legislation in vigor, because you are aware of the Article 46 on prevention of corruption, and according to the requirements of the law, this is the information that is mandatory to be reflected in your declaration. And what is your motivation that you didn't follow the requirements of the law? Thank you so much for your question. I will try to be subsequent in my answers. Yes, we live together, but if it can be interpreted as violation of the law, maybe I would agree to it. I have no other option. I have my own opinion. I can say that there is analogy with Ms. Sukhotska question. She asked about the fact what led you what guided you to address the Cassation Court and Constitutional Court. So the Sixth Court of Appeal was the court of my first instance, first resort. So now it seems that as if I do not trust to the court of the first resort. And here I would like to say that if there is one procedure and I am at risk that my actions will be interpreted as violation of the legislation or the law illicit neglection, and if I am at risk because of my initiative, then I would like to state also the provisions of international law that guarantees for me my rights, and collision or conflict of interest between international legislation, though ratified in Ukraine, and international bylaws. I think this is a theoretical question. It cannot be a crime. Okay, which international law? The Article 46 of the law of Ukraine is controversial too. Now, I meant in the part that there is a free couple. Now, we're talking about the Article 46 of the law of Ukraine on prevention of corruption. So, what the context, why it is controversial to any international legislation? I ask you a question for this law. So in one part you follow it, in the other part you do not follow it. You think this is your right to follow or not to follow the legislation? No, I don't think that I am entitled to ignore the norms of the law. I haven't recognized it, and I will never recognize it. So please, can you explain us why you do not follow the Article 46? In this case, there is a clash of interests in between the spouses in the marriage. Each spouse can have his or her own interest. Because even you have an experience. One of the candidates told, yes, we are talking about you. We shouldn't mention the other candidates. Please, let's talk about you. I respect the interest of the person whom I love. Thank you for your question. Thank you for your answer.
Borysovich, but I will continue with this Article 46. because you are how to say, reluctant concerning the Article 46. But I also would like to ask you a question. You are a lawyer, yes? You became a lawyer in 2003, as I'm right. Are you a member of the Ukrainian Bar Association? Because it is also under the Article 46 of the law of Ukraine on corruption prevention, the declarant shall indicate his/her membership in public associations, charitable organizations, self-regulating or self-governing professional associations. And we don't find your declaration as a member of National Bar Association. How is your interpretation? Because probably you have also your personal, how to say, view on Article 46 in this case, as I could imagine, yes, after your answer here today.
Thank you for your question. I would like to rely on this source. It is not just about my fantasy and my imagination. There is explanation of the National Agency on Prevention of Corruption about electronic declarations. This explanation is on the website of this establishment. According to this explanation, it is written, statement number 8, that family members and membership of the candidate in private associations, in self-governing professional organizations in the sphere of bar and prosecution are not needed to be mentioned in the electronic declaration. So it is the same when we talk about bar association and prosecution associations. Prosecutors do not have any benefits in front of the other side. So this is about this statement. And being based on this statement, as for my being a member of the National Bar Association or Lawyers Association, my name and surname is registered in the list. Now I clarify that I have become a lawyer not since 2003, but since 2004. This is just clarification. Thank you.
But now we have another question. I have another question concerning your apartment and the prices you paid for the apartment. You purchased an apartment for approximately $416 per quadrat meter. Average housing price in Kiev in 2005, because as I am right, you bought the apartment in 2005, were approximately $1,840. Taking into account the fact that the prices are growing rapidly, currently the price for apartment in the building where you live, it's about $2,400 per quadrat meter. Does the declared value of the apartment correspond to the market value of apartments located in the center of Kiev? It is my first question. And then, what are the sources of money for the purchase of this apartment? Could you explain us? Yes.
Thank you for your question. Let me to provide you with an answer to the first your question. As for acquisition of the apartment, as it was formed, I would like also to clarify in this part where the members of the AGE didn't feel my explanation was sufficient.
Це
And I should say that this was
мене як фізичної особи, яка
the
перебувала
agreement of me as the
час, тривалий час,
natural person who, I think, as of 2001 or maybe even more, I was
потім у цього
with the seller. And this seller,
мав наміри,
who had intentions to alienate it,
ну, він мав якісь
he had some
застереження,
warnings to whom to sell it to. And it was suggested to me to buy it, to purchase it.
вартості,
And as for the
вона
cost,
мала технічно
it
малі розміри,
it was very small. It was, seems to me, 48 square meters of total area.
і це
And it was on the last floor, so it had number of floors, and I have specified them already.
однак людина була
But
повністю обізнана з
the person was aware with the level of prices. No pressure was made back then. There was an open procedure with the notary that was notary certified. I mean, the purchase and sale agreement. And the settlement took place based on conditions that were satisfactory for both parties. Given that I could face the corruption risks, I
себе на той
probably I would have behaved in a different way back then if I, if I was aware of it. So to avoid some issues for my career further on, I would have done it in a different way now. And these prices, they were generated at that moment, at that period of time. This is my answer. I have no other comments on it.
No, as we can read, it was not the exact price in that moment. It was, to some extent, a lower price which you paid for this apartment in 2005, as I explained it before. So, but you have
Tak.
nothing more to add to this case.
Так, це
Yes, it is fixed in the agreement for the purchase and sale of this facility. Okay, let's talk about your cars. We also have a question, and it agrees what Madam Hannah just mentioned mainly. You mentioned that you own the car Volvo from 2008 and you acquired it for 30,000 hryvnias. But according to the certificate number 38 of the Scientific and Research Expert and Criministic Center affiliated with the main administration of the Ministry of Internal Affairs, it says that the market value of this specific car is 200,059. And why could you explain such a significant difference between the value of the car declared by you and the value of car established by the expert? Thank you for your question.
сам, хоча це я доклав зусиль,
I
щоб його знайти. Ну, треба
made efforts to find this data,
бухгалтером.
but I guess I used, my skills of accountant. So the explanation,
Лише підтвердить, що
I can only confirm that
переоформлення
when
договору
there was the re-registration of the purchase and sale agreement, the primary citizen was the citizen of Germany who had the entrepreneur activity here, and
справедливо
fairly
саме з його сторони це є закон,
from his side,
що процедура
the
має
procedure had to be completely transparent
відповідати
and to be
і його інтересам.
in line of his interests and the law
В нього є уявлення і закони України.
of Ukraine. That's why, given the
Ну, даних
data
вимог
and requirements, both for the seller and my agreement, we prepare this agreement, but the car was damaged. So before this, it was almost for 2 years without use
Ще також зазнавала там
and
недоліків.
had certain flaws.
Експертиза проводилась не оцінюючи
And the expertise was done not given the market cost of the car, but for the moment of the purchase and sale,
з метою
it was
реєстрації
assessed
дій
for the registration actions, which
документів обов'язково входив
were to be part of the set of the documents. So the assessment of the independent expert,
саме ж там
and
при цій установі
they were in this institution, in the registration department. And the expert, I think, used the wrong cost of the car, because without damage. And I have submitted the evidence. And in the annex, you have the photo of this car. Yes, I know we saw the photo of the car, but you will agree as a lawyer that when you, as a lawyer, conducted or ordered the expert opinion or assessment of the car, then the expert himself saw the car that he was assessing, right? And he was assessing it depending on the state of that car at the moment of the assessment. So let's continue the questions on the car. Also, in 2022, you acquired the car Suzuki, and again, you declared 180,000 hryvnias. That is twice lower than the market value of similar cars in that was manufactured in 2018. So how can you explain this fact with this car? Thank you for your questions. So one thing to mention, I am, even being a lawyer at that moment, I was no specialist in the sphere of evaluation. I know, but you as a lawyer, you know the procedure, right? Well, I was hoping for the integrity of the expert. Okay, I shall speak about the Suzuki. As for the Suzuki car, I have a chance to refurbish or recover the cars. I mean, I have skills. I know how to put them back into practice. So Suzuki, despite the fact that it was manufactured in 2018, and that is in the documents, but it had certain damages because it was in the RTA, road traffic accident. And given this fact, I could purchase it. And as I was purchasing it, I used funds or money that I could manage after I got the heritage, as I told you before. So I would like to clarify. So you bought this Suzuki for $20,000 that you inherited? Yes. So it looks like I'm answering your question. Okay, so tell me please why, when you were registering the car, the service center of the Minister of Internal Affairs, you indicated the cost of the car that is 200,000 hryvnias. Why don't you show the real cost of the price when you register the car in your declarations? Thank you for your question. I had the answer, and a well-grounded answer. It's item 3. That's the additional questions. And here not to abuse the time, I would like to quote. So since the state custom service did the registration, that the control of the procedure of the identification of the customs price, but you have submitted the certificate to the service center of the Minister of Internal Affairs. So why don't you indicate this cost that you have had back then? I think this was a technical error. I was more focused on avoid questions on the declaration of this facility. Please, let's go faster. You also bought the Rover car. Why don't you show it in your declaration? Why didn't you declare this car? Could you tell us in brief? Okay. Thank you for reminding me. This car is like a, historic car, so it was not apt for use. Okay, we just ask you, why didn't you declare this car in your declaration? That's the only question. At that time, when I was submitting the declaration, I was hoping that this car was going to be the donor. So the cost of this piece of junk that I was not going to use as a car. So I was only interested in some spare parts of this car. So, okay, I heard. Maybe I did it incorrectly, probably. This was my... we have timing. Let's move on. This was my mistake.
Listen to the discussion we read and your answer. I see that very often you've forgotten to declare something. And for example, I have also one question concerning your law firm, which is called Ratusha, law firm Ratusha. And under your declaration from 2017, 22, 23, you do not declare any official income. How you explain? You have been a practicing lawyer. How could you characterize the financial performance of this firm Ratusha? Did you have any clients in 22, 23? Did you have any incomes? Because nothing is clearly declared. So we would like to know your answer, your response to this question, to our doubts.
Дякую. Дуже суть.
Thank you. This is a very significant question, and I shall try to be very to the point when answering. As for the size of my income, it is part of my explanations in the annexes, annex to the additional questions. In these declarations, you can see my real income. Indeed, I had clients, I had income, I had expenses, but further on, the activity due to family matters, I lost interest. I have undergone the procedure since, when we lose relatives, I lost motivation. And only in the course of time, I was able to catch up. And now I am more or less on the stable level now. So when I did not declare the income, I had no income. And that's the way it is. If you ask me whether or not I had activity, no, I didn't have activity. I just submitted the reports in the way they were, not violating the legislation on the integrity of a taxpayer. Moreover, as a lawyer, as for the income per 2022-2023, we had the COVID period, 2021, absence of any activity or restricted activity. and then martial law. So I shall not take a lot of your time answering this question, but I should specify that as of 2010, I have a case proceeding that I won in the European Court, and currently the decision hasn't been fulfilled yet. So I have 5 cases of different jurisdictions: administrative, economic, civil, criminal case as of 2003 by the Prosecutor General of Ukraine, and no answers on those cases. And I had a question, how do I survive? I get some money to pay the judicial fees, and that's all, the court fees. I have an agreement with a foreign investor, the citizen of Poland, on demanding this property from raiders, and I expect to get this profit as the final gain seeker. So to continue, to follow up, let's return to your relations with the citizen of Poland, Zbigniew Wróblewski. How would you characterize what are your relations or relationships? Is this the question? Yes, I'm a lawyer. So the client makes transactions to you, yes, on your activity as a lawyer. So he's paying for the services that you have provided to the customer. Not quite. Well, you have the agreement with the citizen of Poland on provision of legal services, and you are providing them, right? Yes, and the money that he transfers to you, you consider to be the charitable assistance, but not for your work. Please explain this. I don't have such a word as charity or charitable assistance, so I do not confirm this. I had the following situation. What I was stating, and I confirm now, that this person, Mr. Zbigniew Wróblewski, had persons. Please, let's not publicly speak about the case, yes, of another person, because as a lawyer, you shouldn't do that, right? I'm just asking you, in your written answers that you have provided to the advisory group of experts, you have specified that you obtained 12,000 hryvnias of charitable assistance from Zbigniew Wróblewski. So that's why we have this question. Why, according to the agreement on legal assistance, you consider these as charitable funds? Okay, thank you. I will answer this question in the way that is true to reality. I'll try to do it. And I will tell you the following. I did not violate any ethics. I won't inform the details of the case. He has trusted persons in the part of the financial cases in Ukraine, where he gives them the order to give me certain funds and to enter it to the to use it as a transfer for the payment of services. So if it's a big amount, the person or legal entities do it. But if it's a smaller amount, because it used to be very small, amounts, because, well, he was okay with this. So then I would pay it. When the legislation was changed, and now all rates of the court fees are on the same level, he stopped his activities. So no new proceedings were open, and I told him, if I knew that you would not pay the court fee, please answer the question. If you want to speak about your professional activity, you can tell us maybe perhaps about the lawsuit that you have submitted to the European Court of Human Rights, in brief, if you may. The lawsuit in case 361, 171. In this the case of Zbigniew Wróblewski, the citizen of Poland vs Ukraine, on the satisfaction for the lost property.
Настав...
For which the provision? This is Article 1, Protocol 1. What was the violation? That he has right of ownership for the property that he was deprived in illicit way, and European Court confirmed it that the reason for violation of his right was the not timely decision of Ukrainian court that entered in vigor, claimed to the brewery state administration about illegality of administrative acts. So in this part, the decisions of the court since 2004 to 2010, the decision was not implemented. So 13 years after, I just renovated his. So I'm sorry, we run out of time because we're limited in time. Dear colleagues, are there any other questions for the candidate? Mr. Volodymyr, please. So I wish you success in your participation to this selection procedure. I would like to return to the year 2019 about the fact that you presented your candidacy for president voting, president election, and the legislation in vigor states that there should be an import of a sum to the Central Election Commission. So is it correct? Yes, this is correct. This is about the 2,500,000. It is stated by the law. So you didn't input this sum, and Central Election Commission rejected your filling in your candidacy. So then you went to the 6th Appellate Administrative Court. Yes, so we talk not about some court fees, we talk about mortgage that should be paid. So we see that Central Election Commission made a legal decision to reject your administrative claim. So you said that the court passed a strange decision to fit the oligarchs' need. Why? You said so. So please answer this question. I won't claim that I'm a very clear person and I don't have emotions. The time confirms that it had been better for me not to use such words, and it puts a shadow on judiciary system. I am sorry taking this opportunity. I say that I'm sorry because it was my, I would say, maybe very intense reaction. Are there any other questions, dear colleagues? Mr. Vasil? I have a small question. Let's imagine that you become a judge of the Constitutional Court. Tell us, please, how would you start your first working day? Mr. Volodymyr, I think this question of my deputy is a relevant one, so please answer it.
Дякую.
Thank you.
Я від цього питання, пане Шакун, шановний,
Mr. Shakun,
щасливий.
thank you for asking this question. I'm happy.
Але я продовжую.
Please be concise and laconic.
Я хочу стати не
The first
лише,
thing, I
членом,
want to become not
суддею,
only the judge of the Constitutional Court of Ukraine. I would like to become a chairman of the Constitutional Court.
Так, очолити
I'm
для
satisfied.
того, щоб
I would like
три крапки. Це там, де
to become a chairman for, and then there is to be continued. Thank you so much. We ran out of time. There are no questions. Before wrapping up, we are giving you an opportunity to finalize your statement to the advisory group of experts. So please, you have up to 5 minutes.
дякую. По-перше, дякую
At first, let me express my gratitude to all the members of the advisory group of experts,
вітчизняним і іноземним, які
to national and international experts who
дослідження дзінькує
gave dedicated
жичі
our part,
до
their time, to investigation of my case.
найперше, що я просив би, в тому, що
The first thing I would like to ask,
кожна людина деліктоздатна від народження.
so
Це
each,
елемент,
every
дійсно,
person
людини.
is delict prone since birth.
Сказати, що це однозначне твердження не можна,
And
тому
we can't
що
say that
дискусії про це йдуть.
this is just a strict notion. There are different discussions, and even on our platform.
Я б хотів би сказати,
That's why
ніхто не є
I would like to mention that there are no exceptions,
своє, можливо, якесь,
but
будемо так казати, те, що я маю нагоду сказати, що в мене не було,
as I take this opportunity
по-перше, я не
to talk about myself, I had no
входив
harmful intention.
і отримати якісь преференції з цього.
I don't want to obtain any preferences,
Дійсні недоліки мені.
but I have my disadvantages. I have to work on them.
І якщо пов'язати це з
And
моєю
if we
діяльністю, я
link
думаю,
it to my activity, I think if my participation today
спільноті,
will be useful for society,
які не могли б бути озвучені,
and there were
інших, і в
questions
світоглядні,
asked
це для чого я сюди йду,
even about my vision. Why am I here? What I would like to change? What is the concept? And we have an ongoing war in Ukraine, and this is a very sophisticated topic. But when I participated in the
інтереси. По-перше,
president election,
і
I had double interest. At first, I would like to fulfill my program and to prevent the war, because only the president
за кордоном,
is entitled to represent the interests on the international arena
і, по-друге,
on
це
request of the Ministry of Foreign Affairs. And the second task is to
ними скористатися, у тому числі
defend the rights of the
влади,
civilians who cannot do it by themselves. And this is access to the
адаптувати під
power and authority through the open elections. I think this
в нас
system should be adopted for Ukrainian system, not to use the heritage from the Soviet times. Thank you so much, Mr. Volodymyr. Now we finish the interview with the candidate, Mr. Ratush.